And in this case, in the statute, we're continually seeing this term computer, and we're continually seeing this term protected computer. And maybe when you read this, you think, I know what that is. But you want to think twice a little bit and check the statute and see if the statute defines those terms in a unique way. And if it does, that's the definition you have to use. And in fact, the CFAA does have definitions of computer and protected computer that are things you want to know about. So looking at the definition of computer, any electronic, magnetic, optical, electrochemical, or other high-speed data processing device performing logical arithmetic storage function. All right? A facility, data storage or communications facility included, but does not include an automated typewriter or typesetter, a portable handheld calculator, or other similar device. So a question I ask about this is, does this definition include this? Does it include your phone? And if you consider this definition a little bit and you ask, well, is this an electronic device? Yes, it's also optical. Is it a high-speed data processing device? Yeah. Does it perform these functions? Yes. I think it's pretty clear that this thing counts as a computer under this definition. Now, the interesting thing about this is in the early, in the 1980s when this statute is first created, these things didn't exist. Nobody knew, really, that smartphones were on the horizon. So it illustrates how a definition could be broader in its initial inception and even later. Now, as you look at this, you see there is this exclusion of the automated typewriter, typesetter, or portable handheld calculator. Well, isn't this a portable handheld calculator? And if so, why isn't this actually excluded? And for that, you'd really have to dig into what did they mean by a portable handheld calculator when they created this definition. They weren't thinking of cell phones because they didn't really exist. They were actually most likely thinking of the old calculator you'd keep in your pocket for math class. So the definitions, even though they're specific, can be kind of flexible, and you have to pay attention to what they're saying. Even more important for our discussion, this term protected computer. And when we were all together in class, I asked for a show of hands, or a discussion about what do you think protected computer means? And the obvious answer that a lot of people gave was, okay, a computer with some kind of antivirus software or firewall or some other way protected from intrusion. That's a logical answer, but it's not what the definition has to do with at all. And what the definition means is a computer that is protected under law by this statute. And that includes, first of all, computers used by financial institutions or the United States government. That's the first category. That's a pretty narrow category. Most computers of private entities, of small businesses, would not be covered by this. So why is this definition in there at the time that this statute was drafted? First of all, financial institutions and the U.S. government were some of the main users of computers, and the financial system is really important to the working of the whole society, and of course the government is important to national security. But that's not the only part of the definition. The definition also includes this part B, used in or affecting interstate or foreign commerce or communication. This definition is what ties this federal law, or allows this federal law in the United States to reach economic conduct occurring between the states. And this gets a little bit deep into the weeds of U.S. constitutional law. But in short, the U.S. federal government does not have a general power to regulate the ordinary activities that are happening within a state. That's left to the state governments. But the U.S. government does specifically have the power, the U.S. Congress specifically has the power to regulate interstate commerce, that is, commerce that flows between the states. And so this means that any computer that involves activity, commercial activity that's flowing in between and among the states of the United States can be covered. Today, really, that means any computer connected to the internet. And we don't have time to get deep into the definitions of what commerce means and how you interpret the Commerce Clause under the US Constitution. But the short answer is it's interpreted very broadly, and there's very little doubt that any computer or device like this phone connected to the internet is covered. So really, a protected computer is pretty much any computer, unless there's something really unique that is keeping that machine completely walled off from any outside network, and there's nothing in any way that connects it to interstate commerce. That's almost never going to happen. Notice the second part of this definition, including a computer located outside the United States that's used in a manner that affects interstate or foreign commerce of the United States. This provision gives this statute extraterritorial effect. And so what this means is that the activity could be happening physically initially in, say, Russia, right? The hackers can be in Russia or Ukraine. And the computers they are using to conduct the activity are in Russia or Ukraine. But they are attacking information that is used in US commerce. And therefore that activity is still brought within the domain of the US Computer Fraud and Abuse Act. So it is still a crime within the US, even though some or all of the activity is physically occurring outside of the US. Now the problem here, of course, for US law enforcement is that you're very unlikely to be able to apprehend the people committing the crime and to extradite them, to bring them to the United States to stand trial. Certainly with countries that we don't have a clear and easy pathway to do that, such as Russia and China. Occasionally, there's stories of them catching a high-profile cyber criminal who's on vacation in Amsterdam or something like that. But in general, that's going to be the real barrier, not the territoriality of the crime, given the global connected nature of the internet. All right, our next really important definition is going to be this question of access and what it means to exceed authorized access. So access without authorization is one way that in certain areas of the Computer Fraud and Abuse Act you can get into trouble. But you can also get into trouble if you have authorization of some kind, but you act in a way that it goes beyond that authorization. And the question here is, what does it mean to be authorized, to be entitled to access? Does it mean legally entitled? Does it mean contractually entitled? Or does it mean technologically entitled? Some courts, some of those appellate courts said, if you violate a contract or a policy document, so your employer says, you have access to this customer database. Here's your password, here's your login. Our policy says you may only use this information in furtherance of the business of the company. And you, having that access, take the information and take a list of customers and start a competing business. All right, so you have violated company policy. Is that a crime that the Computer Fraud and Abuse Act would govern? Because it's in excess of authorization. Some appellate courts had said yes. Some appellate courts had said no, that's not a crime. We leave that to private law. That's a breach of contract claim. That's a trade secret claim. The company can file a claim if it wants. And this issue, because of this disagreements in the appellate courts, recently went to the U.S. Supreme Court and was decided in the Van Buren case that I asked you to read. The way I wrote out the issue in Van Buren was whether and by the way, when you're writing an issue, starting with the word whether is often very helpful. Whether a police officer who obtained information from a police computer he had credentials to access and used the information for an unauthorized purpose, a monetary payment, violated the CFAA's exceeds authorized access provision. The defendant has gone through a full trial on this crime. Now, this can be significant in a criminal proceeding. In U.S. federal criminal proceedings, ordinarily it begins with the prosecutors obtaining an indictment from a grand jury, which is just saying there's enough evidence here that there's reason for the prosecutors to bring the case. The prosecutors file the charges, and then the case is in a court, and then the defendant can, before trial, make a motion to dismiss the indictment on any number of grounds. It could be procedural reasons, it could be the way the evidence was collected, or it could be substantively. It could be that the crime as defined, the argument is unconstitutional, or the facts as stated in the indictment simply can't support the crime. But in this particular case, that's not what happened. It went to a full trial. And when it goes to a full trial, the judge is giving instructions to the jury, saying here's what the law is, and then a jury is making a determination. So Van Buren appealed from the jury verdict to the Intermediate Appellate Court, the 11th Circuit. The 11th Circuit agreed that the defendant was properly convicted. In other words, both the trial court's instructions to the jury and the 11th Circuit agreed that it could exceed authorized access for a police officer to obtain information the police officer had technologically and otherwise was allowed to get in relation to their job, but to use the information in a way that violated a department policy. Then from the 11th Circuit, the case went up to the Supreme Court by Justice Barrett. An individual exceeds authorized access when he accesses a computer with authorization, but then obtains information located in particular areas of the computer, such as files, folders, or databases that are off limits to him. Now, as you look at this definition, in the end, Justice Barrett says, this conviction shouldn't stand given the facts before the court. But you might want to ask, well, is this really a clear definition? Because what Justice Barrett could have said is that are protected technologically, right, from which this person doesn't have a decryption key or a password or something like that. Now, these and that could be part of what it means for something to be off limits, and these files, in that sense, though were not off limits to Van Buren, but as a matter of policy, the use of them was off limits to him. So there may still be a little bit of ambiguity, but what Justice Barrett is trying to do is to say do you actually have some otherwise legitimate access to these files? If so, then if you've misused them in some way, that's not a CFAA violation. Do you not actually have legitimate access to these files? If you don't, then accessing them can be in excess of authorization. You have access to other files on the system, but not to these. I think it's still a little ambiguous. Does that mean only a technological lock, or does that mean could that also mean a policy? You are allowed as a matter of policy to look at this, but not to this. And here, Justice Barrett looks at the text of the statute and says, I think the plainest way to read this language is in the way that I have read it. She looks at the legislative history, which is, how is this statute passed? What led up to the passing of this statute? Were there any debates, or was there any evidence in Congress of what Congress might have meant by the term? And then she looked at policy concerns, and she considered, if I interpret this language more broadly to include unauthorized uses, are we then going to really ensnare a lot of people who are doing things like, maybe surfing the internet during lunch in violation of a company policy? Do we really want to call that a crime? Probably not. So a final definitional piece, you'll notice that in various places the statute talks about damage. And in some places the statute has statutory thresholds, minimum amounts of damage before the federal law applies. So this definition, any impairment to the integrity or availability of data, program, system, or information. One thing to just note here, if you're in the security field at all, you'll probably know the CFAA triad. So this is a basic principle of data protection. And it says that when we're looking at data, we want to have confidentiality so that we are able to keep the information confidential. We want to have integrity, which means that the information doesn't become corrupted. It still is readable. It still is, assembled or able to be reassembled. And we want it to be available, meaning that the information has a purpose. It's used for some reason. If it's a sales database, someone has to be able to look at that information and make, sales projections and budgets and so on. So these things have to really all be taken together. I mean, we could have perfect confidentiality, you can encrypt everything and throw away the key, but then we're losing integrity and we're losing availability. All right, so notice integrity and availability are mentioned here. Why is the C, confidentiality, not mentioned? And I think one of the explanations of that is that there are specific parts of the statute that make compromising confidentiality a crime. All right, but any impairment here is very, very broad. It's pretty easy to meet the statutory threshold for there being enough damage for this statute to kick in. Because impairment includes not only something happening to the integrity and availability of the data as such, it can also include things like remediation costs, the cost of hiring someone to look at the system and try and forensically figure out what happened. And these costs can pile up very, very quickly. So, jurisdictionally, when we looked at protected computer, almost any computer connected to the internet, the damage threshold, very easy to meet. Really, the thing that limits prosecutions under this statute is the resources of the government. The federal government simply doesn't have the ability to prosecute most low-level economic computer crime, or even most high-level economic computer crime. There have to be certain targeted things and ways that they go after it, and that problem of enforcement is another piece of the problem we address in a cyber law class. So now let's move into some of the specific crimes, or let's move in to discuss the specific crimes under the Computer Fraud and Abuse Act. And here, first thing we can pick out is intentionally accesses a computer. And we can keep going and say without authorization or exceeds authorized access. So these are our first two elements: intentional access without authorization or exceeds authorized access. Now notice that this talks about intent. We're going to talk about this a little bit more in the coming week, but criminal law is generally addressing intentional conduct. It's not usually addressing merely negligent conduct or even merely reckless conduct. Usually we say conduct that is reckless or that is negligent, that's a matter for the civil law, for tort law, for example. Although sometimes, and we will see even in the computer crime area, sometimes we do criminalize certain negligent or reckless conduct. But usually we're looking at intentional conduct. And at the very least, criminal law has aspects of what we call actus rea and mens rea. Actus rea is the action. What action was taken? And we're usually saying that's an intentional action, although again it could be maybe negligent or reckless. And then mens rea is what is the mental state of the person doing this crime. All right, so here we have intentional access is our action, without authorization or exceeds authorized access. That is our initial bad act, and through that thereby obtains, and then each of these pieces here is a different third element to this crime, right? So intentional access without authorization thereby obtains one of these three things. So the first piece is certain kinds of financial information of a consumer, all right? The second one is information of a department or agency of the United States. See how this ties to the definition of protected computer? That first piece of that definition was financial institutions and U.S. government, right? So taking that kind of information is intentionally without authorization or exceeds authorized access is a crime. But then this third piece, information from any protected computer. So this first part of the Computer Fraud and Abuse Act is mere access and mere taking of some information. Now, the way computers work today, any computer connected to the internet, simply in virtue of the fact of accessing, there is at least certain information being transmitted, being obtained. So it may be that you access without authorization or exceeds authorized access, and you go into a drive and you extract some files from that drive. That's certainly taking information. But even if you don't take anything, you are technically violating this information part of this statute. So it is a federal crime in the U.S. simply to access a computer without authorization or in excess of authorization, because that access in the internet era is going to involve some taking or exchange of information. Now, when we go through the penalties for the crimes, you'll see that the different kinds of crimes are at different levels of severity, and the different levels of severity result in different levels of punishment, different levels of possible jail time. So this is the lowest level of jail time, but it still is a federal crime that can result in jail time. Now, as we looked at the elements here, taking the statute, I'm showing you here how this looks in the U.S. Department of Justice Prosecuting Computer Crimes Handbook. And notice how all of this language has been boiled down and formatted into these much more simple elements. And this is what lawyers do, and this is what judges do with all of that language. So this is the handbook that a federal prosecutor would use to say, do I think I have grounds to charge this crime? So the next part we'll look at, and we're just going to go kind of briefly through each section of the Computer Fraud and Abuse Act, is accessing and defrauding to obtain value. And that's part A4. So here are our elements: knowingly and with intent to defraud, access a protected computer without authorization or exceeds authorized access, and by means of that conduct furthers the intended fraud and obtains anything of value, unless the object of the fraud and the thing obtained consists only of the computer and value less than $5,000. All right, let's break this down a little bit. Intent to defraud. So this word defraud or fraud is not specifically defined in the Computer Fraud and Abuse Act, but fraud is a well-known term in American law. And so if a statute is using a term that is well-known in American law and doesn't give it a specific definition, then we have to consider what does that term generally mean in the law. And generally speaking, fraud in the law is knowingly deceiving someone to obtain something of value where the person has no reason to know that the representation you're making is deceitful. So fraud is not merely telling any untruth. There is part of fraud that says the person who is the recipient of this conduct has a certain, is presumed to have a certain degree of reasonable knowledge. So, if I say to you, hey, I happen to have found the deed to the Empire State Building, and the building is worth hundreds of millions of dollars, and maybe $1 billion. I'm short on cash, I'll sell it to you for $1,000. Yeah, I mean, am I doing it knowingly? Am I doing it with an intent? Possibly. But would it be reasonable for you to actually believe that I have the deed and that I'm able to sell it to you? Probably not, right? So anyway, the whole purpose of this part of the Computer Fraud and Abuse Act is to say that a fraud crime involving a computer is its own kind of crime. All right, we already have fraud crimes on the books in general. So why do we have a separate computer fraud crime on the books? And the reason for that is it is a way, first of all, of indicating that there's a particular kind of fraud that we think is prevalent and important that we want to have criminal law about. But it's also to say that somebody can be charged with more than one crime. So you could be charged with ordinary fraud, and you could be also charged with this section of the Computer Fraud and Abuse Act. And there are going to be questions then about, how those relate to each other. Do you have multiple sentences? But this is a way that it gives prosecutors more to charge and more leverage potentially over a defendant. So notice here that we have conjunctive test. All right, you need this, and this, and you need this. But we also have a conditional, which is the word unless. So even if we have all these other things present, if one of these conditions obtains, then there's no crime. So what is the condition here? The condition here is basically a monetary jurisdictional threshold. So the original idea of this part of this statute is we're not going off. The statute is not meant to go after what we might consider low-level fraud or low-level computer fraud. Now, it doesn't mean low-level computer fraud is just okay and legal. It just means federal resources, federal crime aren't going to deal with it. Maybe state resources will deal with it, or maybe something else will deal with it. Now, the twist with this, as we have seen, is this question of value and damage is very easy to satisfy, and so even something we might consider low-level still potentially could trigger this statute. It would just be a question of whether prosecutors are actually going to take the trouble to try and enforce it. This then is how the Federal Computer Crimes Prosecution Manual breaks down and sort of reorganizes in a neat way those. So then Part 5 of the statute actually contains 3 different possible crimes, which can make it a little confusing, but when you break it out, and I've just given you here to make it a little simpler, the actual breakout from the Computer Crimes Manual. This is a more recent, more contemporary amendment to the statute, because this is a malware provision, right? Knowingly cause transmission of a program, information, code, or command is our first element to the first part of the first crime under this part of the statute, and that is specifically designed at getting to malware. All right, and conjunctive, as a result, intentionally cause damage without authorization to a protected computer. All right, so intentionally cause damage, sending some malware to intentionally cause damage. As we've seen, the damage threshold is pretty easy to meet. But intent, what if you transmit some kind of program, information, code, or command, and you're not intending to cause damage, but some damage nevertheless is caused? Well, that's a place where this part of the Computer Fraud and Abuse Act goes a little further than the usual criminal place of intent. So notice that Part B talks about recklessly causing damage, and Part C doesn't say anything. It just says causes damage. So Part B allows a claim for recklessness if damage is caused. Part C allows a claim for negligence and perhaps even a strict liability kind of claim if any kind of damage is caused. So Part 6 is a trafficking provision. So trafficking in the law is thought to is a kind of commercial activity that is illicit. So human trafficking, right? You're trading people against their will, either for enslavement for manual labor or for sexual acts or prostitution, right? Things like that. So trafficking, computer password or similar information, knowingly with an intent to defraud, and that trafficking affects interstate or foreign commerce, or it's a U.S. computer. So selling passwords, selling decryption keys that you have stolen that you don't otherwise have a right to, or that you're otherwise selling as part of a scheme of fraud, violates the Computer Fraud and Abuse Act. And again, this interstate commerce hook is that jurisdictional hook that allows, or that hook that allows the statute to exist under the Commerce Clause and is interpreted very broadly. So this will include any trafficking in such information over the internet. Part 7 is the extortion part of this statute. And this extortion is, possessing something, usually that you're not entitled to possess, or that you came across illicitly, or that you're not normally entitled to disclose, or that through disclosing you're going to cause some particular kind of harm to a third party. And in exchange for not disclosing that information or for giving that information back to its rightful owner, you're asking for money or some other value. So intent to extort money or other thing of value, transmitting a communication through interstate commerce, again, anything on the internet, which contains a threat to damage a computer, a threat to obtain information from a computer without or in excess of authorization, or to impair the confidentiality, or a demand or request for money in relation to damage to a protected computer where the damage was caused to facilitate the extortion. So all of this language, it covers a lot of things, but the key thing you want to keep in mind that it covers is ransomware. So it's multiple crimes usually under the CFAA to do ransomware, because you are probably transmitting a code, you are probably accessing without or in excess of authorization, so you have multiple levels of crime there, and then you have obtained some information and you're encrypting it and you're not giving it back, so you have impaired that information or damaged that information. And so this is the part of the statute that ransomware is charged under. Part A3 is the access to a government computer. So again, intentionally without authorization, access a non-public computer of the United States, and that conduct affects the use of the computer by the government of the United States. Why is this separated out from other access crimes? Because it will be a different level of penalty. In general, we're going to give a higher penalty if you're getting government information, because that can potentially affect national security. And then we have a separate part of the statute, actually the first part of the statute, specifically about national security information. And this is a pretty long and convoluted section. So to try and break it down into elements: knowingly access without authorization or exceeding authorized access, by means of that conduct, that access, obtain information that is determined by the United States government to be classified, to affect national security, right? So classified information. And obtaining that information with reason to believe that the information could use to injure the United States or to advantage a foreign nation, communicating, deliver, transmit, and so on, that information, or failing to return it to the United States. All right, so that's a kind of summary of the different elements of the different crimes under the CFAA. This slide gives information on the potential jail sentencing for these crimes. And I don't want to go over this in a lot of detail, but let me point a few things out. The things that are not in parentheses, so here 10 years, or here 5 years, are for a first offense. The numbers that are in parentheses are for a second or subsequent offense. So as is usual in American criminal law, if you commit more than, you commit the offense again, the penalty goes up higher. And you'll notice that the potential jail, and these are maximum jail times, and there's a lot of different factors that would come into play about how much jail time a court might give, a judge might give if you are convicted. And it's going to vary depending on severity. So national security information, which is considered a pretty severe offense, is a lot of years in federal prison. Mere compromise of confidentiality, could be as little as 1 year. Now, nobody wants to spend even a year in federal prison. Nobody wants to be convicted of a felony, which has a lot of other implications, but a lower sentence. So you can kind of look through this and see what the different sentences are. The most serious one is knowing transmission of, a code, virus, something else like that. Intent to cause damage, where there is an attempt to cause, or knowingly or recklessly cause, death. Now you might think that seems kind of far-fetched, but we will be talking about and think about things like attacks on water supplies, things like attacks on pipelines that might be cyber attacks, but that might have effects that actually could cause people to become ill or die, and that's a potentially very high offense. So all of these, potentially carry some jail time. Many of them, if you kind of are guilty of a number of different provisions here, can result in some very significant jail time, and that is one of the issues that was debated in the Aaron Swartz question. Given what he did, he was charged with a number of offenses that could have resulted in 20 years or more in federal prison. Is that too harsh, or is that appropriate? Those are some of the policy questions that you would discuss in terms of punishment under this statute.